There we go. Okay, looks like there we go. All right, recording is started. Yeah, there we go. Welcome back, everybody. Okay, we've got 6 so far. I think Amanda was planning to be here and possibly Beth. I'm not 100% positive, but we can go ahead and get started. Um, if we if we need it, we do still have a couple of days next week. However, my hope was we might be able to get the bulk of the rest of this finished with just some potential language tweaks to finish out over those couple of days. So at this point, before we move into performance standards, um, is everybody, does everybody feel comfortable with the role definitions and qualification standards as we've set them out so far? Yeah, I'm seeing thumbs up. Cool. Some head nods. Awesome. I think there was one question that had come up about the paralegal standards, which say in addition to the requirements for office support staff, I didn't want to say in addition to the legal assistant role because legal assistant already has a time requirement in there. And I felt like I don't want to put the paralegal portion on top of the time requirement for legal assistant. Um, so I just want to check, does everybody feel good with that? Or, okay, cool. All right, so let's move on then to performance standards. What I got out of the standards from NALA, and I'm trying to look through some from NFPA as well and see if there's a big difference, which it doesn't look like there's a lot. Really, the big things that they've been highlighting are making sure to clarify the difference between paralegal and legal assistant and attorney. Oh, we got another. Cool. Let you in. Make sure that confidentiality is highlighted. Awareness of the rest of the attorney's rules of professional responsibility, and then very explicit things that that are not part of a paralegal's or legal assistant or office support staff role. I kind of threw in a possibility of, we'd been talking about CLE credit, and then I threw in a placeholder for workload, though I don't think that that is the scope of this work group, at least not at this stage, other than perhaps something marking or indicating that an attorney who is engaging a paralegal should take care not to overload either their competence or their just like time capacity, if that makes sense. So what are folks' thoughts on these?
Sounds good.
I just want to clarify.
Sure.
I just want to clarify something. So I know we touched on it the other day, but like someone coming into the para field, is this new requirements or stuff they should already have in place?
Is what a new requirement or stuff they should have in place?
Uh, the standards, the roles.
My thought is that the performance standards are things that are what we expect people to do while they are performing the role, rather than how do we know that they should be allowed to do it. This is what are our expectations regarding people who are performing this role.
Okay, thank you.
Which, there's in the office support staff, it does say understands confidentiality requirements. that's, you know, you got to know what this standard is before we're going to let you do the job. But once you do it, like once you're in there, you're subject to these standards,
Right.
if that makes sense. Okay. Well, there's some draft language from Nala I can throw in. Nope, that's the dependency standards. That's not what I want. Good Lord.
Let me shoot her a message and either she or I will.
Oh, where is it? Okay. Does anybody have any thoughts on how we want to phrase the clarity of role? One thing that I wanted some guidance on is who should have the responsibility of ensuring that the client is aware of the role distinction. Because I think this is where there is a split on some of the different jurisdictions. Some people say it's the paralegal's responsibility. Some say it's the supervising attorney's responsibility. We could say it's both. With like the caveat, both. Okay.
Well, because like as an legal assistant or paralegal, it's our job to let the client know that I have like a little blurb as I am not an attorney, I am not authorized to give legal advice, yada yada yada. But it's also the attorney's job to say like this is my legal assistant or paralegal, and they are not allowed to give you legal advice. So I think it falls under both, in my opinion.
Okay.
Agreed.
Okay. One of the things that we have, how do I want to put this? There are some standards that, I don't know if anybody here is, Amanda, you might be familiar with the OSB standards for delinquency, dependency, criminal work, those kinds of things. Those are excessively long documents and can be confusing at times. So I don't think we've landed on how explicit we want these standards to be. Do we feel that this is comfortable, or do we want to, like, I've got the start of a second like sentence here about what are some of the communication things that paralegals and legal assistants should do to maintain this clarity, like using a title that doesn't reflect being an attorney, and you know, making sure that communication explicitly says either that it has been reviewed by an attorney and approved, or that this is coming from the paralegal and is not itself legal advice, something along those lines. We could have that. We could choose not to. That may be, at this stage, we're good with something less explicit, but later on we might say, in a future iteration of this kind of work group, we might say yes, we want more, or we say we want more now. What are folks' thoughts on how thorough or explicit to be about components of these standards? Amy, you're muted.
Sorry about that. That's the first time I've done that. I was wondering if can't we just go through the NALA, the Paralegal Association rights that one of the documents you provided us, and you've used some of that information from it. I mean, can't we just go through it, the standards, and kind of like agree together as a team what we want to take from that? Maybe would be easier than us kind of throwing stuff out there. So that way we're kind of like covering everything, but also like we don't need everything from it. And we don't have to like obviously go through every single word, but kind of when it talks about the guideline, each guideline maybe agreeing, because I've highlighted a whole bunch of stuff in here that I think we need to use. But again, that's just my opinion, and that would be my suggestion.
I'm good
See
with
what others
that.
think.
Amanda, you've got your hand up too.
Yeah, I think Amy is amazing, and we should do whatever she suggests. And also, I definitely don't think we want the length and the detail of like the bar standards for the different practice areas. That's way too much. And I think if that applies to attorneys are then responsible for maintaining those standards within their office. I do think, but I also have like an unrelated request, Kevin. I don't know if there's any way to make this bigger. Yesterday, I
Yes.
was much more, last time I was more familiar with the section we were talking about, and so I didn't need to read it all, but this is when, yeah, I just can't see it.
Thank you.
So thank
I
you.
forgot to, I had zoomed out while I was working on it myself, and then I forgot to zoom back in for the work group. So yes, absolutely not a problem. Okay. Okay. So sure, let's Amy, if you've got identified pieces that you want to pull, I will see if I can copy and paste straight out of the NALA model guidelines from where you're thinking.
Yeah. So, and this is where I need help because I just
Sure.
highlighted a bunch of stuff thinking like this somehow it needs to be incorporated in here. Like I don't know
Right.
exactly where or what, but I feel like on page 5 I feel like we've got that in our in the qualification standards, right? So
Yep.
now I was going to page 7 where it talks about disclose. We have to disclose our status as a paralegal at the
Right.
outset of a professional relationship with a client. So I don't know if we can use that language to describe how we like our, responsibility to disclose that to a client. I think where we're at here.
Sure. No, actually, I think that's a great,
You know what I mean?
let me
Like,
just swap that language in. Hey, it did work, sort of. Text only. There we go.
wonderful. I mean, also we are supposed to preserve in the confidence and secrets of all clients, which we have. Gosh,
I think all 3 of those are actually really
right.
good. So
I mean, can we
Yes.
just steal it and then just like
Yeah.
put that it's from the NALA guide, like reference that we stole it. I'm all about stealing as long as we reference.
Right.
Like,
Why is that now? What is wrong with that spelling that is causing? Weird. Oh, hold on. Is that why? That's why. Okay. Okay, so yes, let me make sure that I've got things capitalized consistently. You know what? That's copy editing. I can do that later, not in the confines of a work group. Okay. And yeah, I stole this language straight for like that's where I got these first 3 standards was just literally just from guideline number 1. I just split them into 3 because it seemed more appropriate for our purpose to have them separated.
right. And it's okay for us to use these because this is essentially what paralegals are supposed to be doing. So
right. I mean, if you're certified by NALA, then these are the guidelines that you have as well. So
yeah.
Exactly. And then just page 9, the things we should not be doing, which is the establishing attorney-client relationships. I think we've already, I feel like I read that on here. I have it opened up over in another screen. So
I have that as standard number 4. I don't like the
right.
phrase forbidden tasks as the title of that standard. Does anybody have
Yeah.
something that fits? Like that's just like
right.
too on the nose, maybe?
Unauthorized?
Oh, I gotta think about this one.
Maybe. Or maybe
Oh my gosh.
maybe something
See, I see where she said unauthorized because down below it says or contribute to any act with which could
task.
Constitute the unauthorized practice of law. I don't know.
Maybe tasks exclusive to attorneys.
There you go.
Yeah, that's better.
Okay. And then I didn't have good language for what to say about the rules of professional responsibility. Let's see what Nala put in there. Yeah, sure. Oops. That's why it did that. Did this. Yeah, it should be heading 3. So what's wrong with this?
Should we make it specific to the Oregon rules of professional responsibility?
Yes. Is that titled specific to attorneys or something? Let me see what the bar explicitly calls them.
Did you need Jen?
Rules of professional conduct, not, okay. Oh, I should have just opened, I have the ORPC's hot. Okay, hold on. Yep, okay. Oh, that's why. That says it's that should be normal. There we go. That's better.
The standard 3 titles say rules of professional conduct.
Yep. Okay. And why is this? Nah, I like the word general there.
I think you should specify that we're talking about either the Oregon State Bar's rules of professional responsibility or or Oregon's rules of professional conduct for attorneys, so that we're specifically saying these are the
Yeah.
lawyer rules you need to be familiar with, not some other rules that refer specifically to paralegals.
Do we need to self-reference these standards in the standards? I feel like we
put a
could,
link.
no, like this phrase, understand the Oregon rules of professional conduct for attorneys and these standards. The and these standards seems like it's
No.
not really applicable here.
Oh, yeah.
Nope.
Attorney in a violation of the rules. Or give the appearance of professional impropriety. Yep. Okay. Okay. Maybe there's not a lot of language workshopping to do. How do folk feel about these so far? Yeah. Okay. Amy, did you mark anything in the comments to the guidelines that you felt would be good for inclusion?
That would be a negative.
That's fine.
I pretty much just went through all the guidelines.
Okay.
So I have a lot
Is there
more.
Is there anything? Oh, you have more. Good. Let's go.
Well, I mean, I just think, and this is, you guys can correct me if it's just too much. Like, I don't know how much we want to add, but on page 10, it just kind of goes back into the, like what we can do, like the services that we can provide. So I don't know where we want to add that. Just like another standard, maybe. There's clarity of role, client confidences.
Yeah.
So then we have paralegals may perform services for an attorney in the representation of a client provided, and then there's bullet points.
Maybe something like delegated
Tasks or no,
delegated legal work.
That works for me. Anybody else objects or has better language?
Up above, don't we kind of lay out the things they would do? So I don't know if it's redundant or if we should add this piece there or.
Yeah, so that was my question, because I can go over them. Do we already say somewhere that the services performed by the paralegal do not require the exercise of an independent professional legal judgment? The attorney maintains a direct relationship with the client and maintains control of all client matters. The attorney supervises the paralegal The attorney remains professionally responsible for all work on behalf of the client, including any task taken or taken by the paralegal in connection therewithin. And then the services performed supplement merge with that. We don't need that.
So maybe we need less because we do have tasks explicitly identified up in the role definition, but maybe here we set out the standard that the attorney is still responsible for all of the work product and ensuring a direct relationship with the client and supervision of the work being done by the paralegal. And then I would assume that this also applies to legal assistant. When looking at standard 3, the rules of professional conduct, I only said that applied to paralegals and legal assistants, largely because in I think our framework, the office support staff is perhaps less has fewer of those tasks and responsibilities. But is that necessarily accurate? Do we want to be more explicit? I kind of feel like for nearly every work group that we have here, except perhaps, yes, you're right. Thanks, Megan. Except perhaps for interpreters, even like if you're translating in a confidential, like privileged conversation, the contents of that conversation are still going to be subject to confidentiality and things. Are there
I think we specifically state that everybody, I think we've already stated that everybody is subject to keeping the client's confidences. I know that I made that edit above where it wasn't in there initially for the office workers or whatever they're called, office specialists, but I don't think that we require the lowest level of admin staff to be familiar with the Oregon rules of professional conduct, because there's a lot there besides confidentiality. Right. There's so much that they're never going to have contact with. And again, they're going to be supervised by either an attorney or a paralegal. I just think we hammer that everyone's responsible for confidentiality and confidences, but I don't think we make the office support folks be responsible for the whole body of professional rules.
Okay. And that makes sense to me as well. And just for everyone's, like, I may look at these and reorganize which ones are where to provide more of a, as you climb the ladder, these are the further standards that apply to you progression or some other like theme as to what the order of them is, but that's a copy editing thing. So okay, so what let's see, the language under delegated legal work, and then this is normal. Yes, it's in normal. Okay, sorry, Amy.
Okay, no, so one more thing now that I feel like we're moving along here. So if you go to page 11, the guideline 5, so we have the standard for tasks exclusive to attorneys. Can you remind me, did we add a standard for tasks like exclusive for the paralegal or legal assistant? Because I feel like I'm looking at the last draft that you sent us, and I'm not seeing anything where it talks about like what the paralegal can do as far as conducting client interviews and maintaining general contact with client, locate and interview witnesses. Do we need that? I mean, I just don't know like what we're looking for here.
I didn't have any of that in the standard, in the performance standards, but I did have that up in the role definitions. So communicating with clients, and I put to obtain information relevant to legal research. We can change that language because that was just like, I'm not sure that that's necessarily, that might be too narrow of a scope for client communication. These are all things that I kind of pulled partly from, actually, I think most of them were pulled from the 6-year, the draft of the 6-year plan. because there are specific tasks identified in there that we wanted to pull away from attorneys. So this stuff from guideline 5, we can certainly use to revise the language in the role definition to explicitly describe which tasks are associated with that role.
And I think that's what you guys did on day one. So I don't want to take away any more time. If everybody's agreed on that, I think that's fine to keep it that way. I just noticed that there's a lot more here that could be added if anybody thought it should be.
I don't think somebody correct me if I'm wrong, but I don't think we pulled from this document for that on the first session, and I'm certainly open to increasing the list of tasks like
I think we
associated
just
with.
kind of went through and from our experience pulled tasks. So,
Yeah.
but this is a good list too. So
I say the more the better. I want to use my paralegal to do everything that he can possibly do to help me. And also I think for attorneys that might not be really familiar with utilizing their staff, especially people that work for OPDS that haven't been able to bill for it, it might not occur to them all the things that you can use your legal assistant or paralegal to do. And this is really helpful.
I vouch for that because I came from private practice and the tasks are a lot less in a state agency. So I'm going to back you up on that. Just for the more, the better.
Okay. So I like the way that they phrased that first client interview and contact piece better than what I had. I want to kind of say that locate and interview witnesses, this is more of an investigation function. I'm not saying that paralegals shouldn't be allowed to do it, but it may be more, we may find that this function is more, and for those who don't know where that's coming from, that's in the NALA guidelines as one of the listed tasks. That seems more like something that would be explicitly referenced in the investigator role.
unless you're just talking to the client and asking names, maybe, but I would say
I want to leave it in just because I think it's an either or.
Sure.
I mean, I think it's a both and, not an either or. And I like when I'm like brand new to court appointed cases. So I'm on my second one right now, but I can tell you in my criminal defense privately retained practice, I do have a contracted investigator and then I have my paralegal. I only bring my investigator in when I need investigation. And then if he's on the case, he might do that task. But I have a lot of like little cases that don't need a lot of investigation. And that's what my paralegal does. So I think we should have it there so people can use whoever it makes sense for, or they can work together on those tasks.
I was going to say the legal description or not legal description, the job description for the paralegal position here at OPDS in the trial division actually says interview. So as the paralegal. So I think you should probably leave it in.
Sounds good. There aren't really, okay. Conduct investigations and statistical and documentary research for review by the attorney. Yeah, that's substantially different enough. Okay. Okay, don't want the period there.
Can I ask a question?
Absolutely.
So, as you know, I'm on the investigation side. So I know that we have to, like our support staff, if a client calls and starts asking about their case, we tell them, don't talk to them. So as in the parafield, what divides the part to where you have to be a licensed investigator to talk to the client. Is that a crossover? I'm probably not asking that good, am I?
What?
I guess as far as the paralegal, when it comes to where it said investigate, um, what can a paralegal do on investigations? What is that limit?
That is a very good question. And that's kind of like that gets kind of into the we want to be mindful that investigation is a separate role that is going to be explicitly defined as well by OPDC. So there may be a limit here.
Kevin, if I could chime in, this is Nate.
Yeah,
go
ahead.
I was thinking about that too. The way the NALA thing is written almost seems like it, I don't know if it's just because it also talks about statistical and documentary research, if it's like emphasizing that part of a quote unquote investigation as opposed to like interviews or something like that. But I'll just say from I agree with what Amanda was saying, especially about like leaving as much in here as possible, as long as it's appropriate for, for a paralegal to jump in and help with, because, especially on a, solo or small, small group of lawyers or something like that, if, you don't have an investigator on a particular case or they're not immediately available, but you do need somebody to take some kind of action to where they are, potentially like, going to need to take a statement from somebody or, be a witness or something that helps shield the attorney from getting into that kind of position or something. I think the more open, the better. And I don't see any way where it would necessarily harm or get confused with the investigator part, because like I think the attorneys are going to use the investigators primarily as the investigator, like they are skilled in, like, so I think the attorney definitely suss out the appropriate use of staff and paralegals and investigators. That's my 2 cents.
Do we maybe want to just get rid of the words investigations and in this standard?
That's what I was wondering, if it's just,
Yeah.
you can be a teenager and investigate a situation. So is it just a word?
Because I feel like locate and interview witnesses, that's not an investigator role, but it is something a paralegal might do. Conducting statistical and documentary research, further kind of research seems paralegal oriented. Okay. I think, let me pull the NALA standards back up. Okay. So then we've got conduct legal research for review by the attorney and draft legal documents, which I think I've already got in here. Draft correspondence and pleadings for review by and signature of the attorney, which I think, would that still fit under here? The undersuper draft documents requiring substantial legal research. It doesn't include correspondence. Janine, were you saying something?
No, but I can chime in. I mean, I think that what we had in there is kind of the same thing as what those two, the draft legal documents for review and the draft correspondence and pleadings. We have, under the supervision of an attorney, draft documents requiring substantial legal research. I mean, I think that kind of is the same thing.
Okay.
And I think it's okay to kind of repeat it, and because they're in different sections, right? One is, like, so one is, you might, I guess they could be a both and, but I think it's good to have that specifically under the standards list as well. Yeah, I don't think it's a problem to be, I think the one before is more general and this one is more specific.
Do we want to just say documents and correspondence?
Yes.
Okay.
The only thing I would say about correspondence, and maybe I'm wrong on this, and I'm sure Amy will tell me if I'm violating the NALA standards, but I would review a legal pleading or a legal document that my paralegal drafts, but I would not review all the correspondence by any means. So I don't want the correspondence to be subject to attorney review. If she's like emailing people, that's
I
correspondence.
think that's up to the
I don't have
attorney
to.
because I've had my previous attorney in private practice reviewed everything. Like I drafted everything from scratch. She reviewed it all and then it went out. Whereas in like a state agency, we have merges and created, cover letters already that I would just send out to the client that the attorney's probably already reviewed way back in the day, right? So I think it could be either or. So I think it's probably better to add it than not have it, maybe.
Well,
It would
and,
make
and
sense.
supervision can take multiple forms.
True.
And then the other piece of it being requiring substantial legal research is a modifier on this as well. So routine correspondence wouldn't necessarily be covered, but correspondence that requires substantial legal maybe research, or is there a word in that we want to add in there? So requiring substantial legal research or judgment?
Yeah, or advice or direction. Not sure.
Attorney
Maybe advice.
direction. I guess it already says attorney on there.
I don't like the word requiring with advice. Discretion, maybe? No,
I like
don't
that.
Yeah?
You don't like that? I like discretion. I don't know.
I'm iffy on it. It's not my favorite word, but maybe it'll fit for now. Okay. And I wouldn't be surprised if there's some language workshopping that happens after the work group is over too. So, because this is just like the first phase for a much longer project, but okay. Okay. So that moves to the next one from the NALA Guideline 5 is summarize depositions, interrogatories, and testimony for review by the attorney. I think, is that covered by review, summarize, and highlight significant events in discovery? We don't really get a lot of depositions in the criminal field, or really, I can't say that I've ever had, even though there's authority for them, I can't say I've ever seen a deposition in a dependency case. And I don't think Oregon uses interrogatories at all, does it?
I mean, I did dependency law for 10 years exclusively in Oregon and never saw a deposition or interrogatory. So
Same.
I feel like we probably don't need to call that out explicitly. It might be like, well, why did you say this? Okay. Attend executions of wills, real estate closings, depositions, court or administrative hearings, and trials with the attorney. I think I could probably get rid of everything other than court or administrative hearings and trials. And then author and sign letters providing the paralegal's status is clearly indicated and the correspondence does not contain independent legal opinions or legal advice. I feel like that, do we want that? We could put it in both places. I feel like that fits to an extent here, but also in the standard number 1, the clarity of the role. So maybe a paragraph. Oops. For the paragraph. Okay, whatever.
I agree. Juveniles are different. There's a lot of similarities, but the rules are very different. So having a separate juvenile certification might be useful. maybe just one juvenile, not splitting it up for major and minor. Maybe just.
And then I'm going to put that here. Okay. How do people feel so far about this? And then we had a different guideline that we were starting up, and I think we did not, what was it? The delegated legal work, which looks at, I'm just going to pull the language really quick. There we go. Okay. 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 How do people feel about this so far?
I think it's great.
Okay. That is, it looks like all of the guidelines. Amy, did you have anything else that you'd pulled out to add? Okay.
Nope, that's it.
Cool. Okay, so let me clean. We may end up being done a little bit early today. If everybody's good with the like first draft of this, I will take some time to clean up the language. Oh, we did not. The other standard that we didn't I don't think that we fully addressed was continuing legal education.
Oh,
So, and then that's also heading 3. Okay. So, did we maybe my memory of this is off. Did we land on, that should all be normal. That's what's wrong.
I think they said 10 hours, right?
Yeah, that's
But
what I
I
put as I thought a placeholder, but I'm not 100% sure.
I
Ah,
also highlighted something else in another handout that you provided. It was the rules of professional conduct and ethical considerations. It just says something about paralegals should aspire to participate in a minimum of 12 hours every 2 years to include
Okay.
at least 2 hours of ethics. I don't know if we don't need to get all like, you know, what kinds of CLEs, but I don't know. But I think everybody else agreed 10 hours every year. So
No, that's exactly how it is.
somebody want to chime in on that?
I just watched last week since I had missed it, and I think there wasn't a decision made on how many hours, but they were talking about, or you guys were talking about 6, because that's what was required of the attorneys as far as OPDC went.
Right.
Which makes
Yeah, I
sense.
think-
That's 12 hours every 2 years. That's 6 hours a
Yeah.
year.
Yeah.
There you go.
Yeah.
Yeah, that's the contractual obligation for attorneys who operate under a contract with OPDC. So I'm cool with like y'all know the industry better than I do. So if 6 sounds right to you guys, good by me. Keep in mind that the standard for the contract is explicitly CLEs within the type of law that you are on a contract for, and is, you know, in theory, part of the roughly 15 per year that the bar requires, which can be on anything, with some explicit, like there are some very specific requirements, like you have to have one every 3 years, you need to have at least one abuse reporting hour, things like that. Are there any that we would want to throw in here as an explicit? I would
I have
not.
an opinion on that.
Go ahead, Nathan.
I mean, just in terms of, I think leaving it very flexible is probably the way to go. But I think for staff, or paralegals, if they're doing practical skills credits, because the bar and other organizations do a lot of really good practical skills CLEs that maybe aren't directly related to criminal juvenile law, something like that, but they're related to office stuff or technology or security, so I think maybe not necessarily making a requirement, but saying practical skills credits, ethics credits, and anything related to the, OPD or public defense work would be solid.
I would,
Kevin,
I tend
we talked
to agree with you. Sorry, go ahead, Amanda.
we talked about this a little bit last time, and I'm just remembering a lot of the conversation that's overlapping with today. And so when we talk about the OPTC requirements for attorneys, as you said, those are like a very minimum. So I don't think, so paralegals aren't required to do 45 CLEs every 3 years, right? Or 15 a year. So OPDC already knows that attorneys are doing, on average 15 a year.
Right.
And then they're just saying 6 of these have to be in the field that you're appointed on. So attorneys are doing a mishmash of CLEs. They just got to make sure 6 are within their contract area. So I don't think it is like the same as what we're talking about for paralegals, because we don't necessarily expect paralegals to be doing more than this requirement. They're not required to in any other way. And I agree with what was just stated about making it as general as possible. And by doing that, I would not call out the areas. I wouldn't require any amount to be in any specific area. I would just have the general number of credits, because the attorney should be able to tell their paralegal, I want you to go to this CLE or I want you to go to that CLE, so that if the person is really up on technology and, office management, you're not going to require them to do that, but you might want them to go to the murder CLE because you have a new murder case. So I want the attorney to have the flexibility to have their paralegal do the classes that both of them think would be most helpful. But maybe in terms of the number of credits, we could split the baby between 10 and 6 and call it 8 a year. I don't know why, but I guess 6 just seems really low. Maybe it's not, and maybe it's better to start low and we can always add more since this is a new requirement. I really don't have a strong opinion either way, but I just do think that we shouldn't state the type of credits that they're getting. Leave it open for the individual paralegal and attorney to have some flexibility.
And I would note that Standard 5, which we just pulled in from the NALA guidelines, also requires or tells attorneys that they should be providing continuing education opportunities as well. So that fits in here with a more general, the attorney may want to exercise more like judgment themselves about which CLEs the paralegal should be attending. Okay. How do people feel about 6, 10, split the baby at 8? 8 would be roughly half the amount of time an attorney should be spending in CLEs each year.
I think what we have is great. 6
Okay.
a year.
All right. So that would be standard number. Yeah.
So this whole document is related specifically to public defense work, right? So why have this in here and even require it if we're not going to require it to be training that relates to public defense in some way? Like if it's just open-ended, you do 6 hours, whatever the hell you want, then why even put it in there? Just to be blunt, sorry. I'm just wondering, like, what is the benefit to us having this in a public defense minded, document if we don't want them to be up to date, right, on public defense stuff or general practice skills? Sure. I mean, I would think we would want to narrow it or get rid of it. I don't know why else we would care that they do this work if we don't want to ensure that they're staying abreast of public defense you know, issues.
And
So
I'd
if we
for
say
the-
like public defense or general practice skills, maybe.
I mean, I'm just querying what everyone's thoughts are. I'm just wondering why we're not defining paralegal, you know, the standards here for any paralegal. We're saying specifically for someone funded under public defense, these are the things we would expect. So I'm just wondering what everyone's take is on the necessity of putting this in here if we're not going to specify the CLEs are taking or what they're learning.
I'll say for the investigators, ours need to be criminal defense. So ours is like what you're saying, for our criminal defense.
I can
So-
speak to what I was thinking because I think I'm the one that said it. So, I hear what you're saying and it makes sense to me. I wasn't thinking about, I guess I wasn't thinking from the perspective that people are gonna have their paralegals do, 6 hours of estate planning CLEs and then say it satisfies this. But I could see the possibility for that once you've mentioned it. I was, I guess the people that I know that get court appointed, including myself, who only has 2 cases, I do criminal defense. So I can't imagine like what else I would be having my paralegal do that would be helpful to me. But what I was more concerned about was that like the way that the OPDC reads in for the attorneys, that you have to get these credits specifically in your contract area, that for me, I would want to help me do my public defense work. I need my paralegal to know about billing and technology and the Oregon rules of professional conduct and the, criminal procedural rules and all of these things that are not specifically like, this is an OCDLA juvenile law CLE, right? So those are all things that are going to help me with my public defense work more than say having my paralegal go to the juvenile law CLE that I'm going to, right? And that I can then translate. So I agree with what you're saying. I guess maybe we should kind of guard against people doing things that are totally irrelevant to the criminal practice. But that would require us to be very specific. Then it would have to be like, okay, the CLEs are either in your practice area of the contract or, and then list, practical skills, ethics, the things that are more general that you might want your paralegal to do to facilitate your criminal defense contract.
Bobby.
Yeah, I sort of piggybacking off of those. I agree with what Megan said, but by the same token, if say your practice area is primarily in juvenile dependency or delinquency, and then you apply for a job for somebody who does homicides or sex cases, and now your CLEs aren't transferable to that, and then maybe the attorney is like, well, now you have to do these CLEs to be a paralegal for me, and that, I just feel like I've always felt a little bit prickly about the CLE sort of requirement. It just seems a little bit rife for either exploitation or bias, or a way for lawyers to say, hey, now we can get more money from OPDC, or a way to say, hey, we don't want to promote you to paralegal from legal assistant because now we have to pay for all of these other things. And if somebody has a NALA certification and is required to have CLEs through that, then that's totally fine. I just don't know if OPDC is the place to be requiring CLEs. And I totally get the argument of we want our paralegals and legal assistants to be learning and growing and staying up to date with, those sorts of things. I just don't know if a CLE requirement makes sense coming from OPDC.
Megan?
I don't disagree with that at all. And I guess for me, this question kind of arose from, when I was working as a paralegal, I didn't just do public defense, right? I did contract stuff and landlord tenant law. And so, and my CLEs were like, to fill my NALA requirements, were whatever I could get on tape. You know what I mean? So I was just kind of filling them in whatever way was easiest. And so that's where I was coming from in asking this question, because I imagine most people do what I did, right? Taking the path of least resistance and not necessarily what would relate or be most useful for what I was doing. And that's what makes me question if we aren't specific in some fashion, even if it's just to say that the attorney has deemed that, you know, these CLEs relate to the work in some fashion, then I think it's frivolous to have it in here, because they're going to, I mean, to be fair, after doing this job, I don't think anyone's going to adhere to this unless we actually ask them to report the CLEs to us. So I don't even, if we don't plan on doing that, I don't think this needs to be in there at all. But that's just my agency perspective, not my paralegal experience perspective.
I agree. Yeah, I agree with that.
So what if we just tag
I like
in
Megan's
standard 5?
suggestion.
Sorry, go ahead.
I like Megan's suggestion of having something like, or as the contracting attorney deems related to the field. That makes it general enough, but it kind of hits that it's not just up to the paralegal to do what and you're absolutely right, Megan. I mean, I'm, as an attorney, that's what I just did. It's my reporting period. I went and tried to find all the free CLEs available on the PLF website, you know, by video, and just binge watch them. So that's completely fair. And but at least it gives the attorney some role there to approve, yeah, this is relevant, this is not.
Is that taken care of by adding an explicit reference to public defense in standard 5? And then we're not worried about number of hours. We're just worried about making sure that there's some CLE work, because this is a public defense contract, going towards that. Well, not contract, but this is a public defense role going towards that subject matter. And then we just don't need a standard 6.
You're saying get rid of 6 and then
think
put
that's
under 5, he directs the attendance of CLEs as they see fit or something?
Yeah, so like we've got, this is just in the supervision of a paralegal. The supervising attorney should provide CLE opportunities in public defense area. And then, yeah, you can do other stuff as well. That's all. And you might have requirements from NALA or other certificates to do that. But it's the attorney's job to ensure, if you're doing public defense and you're using a paralegal, make sure that they're getting CLE in public defense.
I think that's fine. And I just
especially
want to mention, I don't see us actually collecting. So I think that it's going to save everyone some time and headache if we just say keep what's in there and then go ahead and remove the number of hours.
Yep. Okay.
I agree.
I have to go to another meeting, but it was
I think it's
great.
good, especially I think it especially makes sense just starting out, right? This is the first time we're doing this. And so if later people want to make it more, you know, specific or whatever, that's fine. But I think since we're just introducing this, it's good to have this more aspirational general requirement than something really specific that people have to adhere to.
Okay. That may be our first draft. How does everybody feel about this so far as a first draft? All right.
Good job.
Okay, cool. So I will clean this up and get it into like actual draft form, and I will send it around for further comment. But at this point, I don't know that we need to have another actual scheduled meeting unless people want one. Keeping in mind that Monday and Tuesday are really the only days where that would be feasible. Hearing no outpouring of, oh my God, no, we need to meet again, I think we're probably good. So thank you guys so very much for being a part of this. I really appreciate all of your input and help getting this to the state. I absolutely will be sending this around so that if you have further comment, you can continue to have input. And yeah, fantastic work. We could not do this without all of your help. Thank you so much. Have
Thank
a
you,
great
Kevin, for
weekend,
leading
everybody.
this.
Yeah.
Yes.
Yeah, thank you, Kevin. You were a
Yeah.
great facilitator.
Yes.
Good job. Thank you.
Thanks. All right. Have a great weekend, everybody.
Bye,
Thanks,
guys.
Thank you.
everyone.
Guys.
Bye-bye.